Hello. Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and a partner at the Edwards Wellman Palmer law firm in Boston. The IEEE is presenting this podcast in conjunction with a series of articles that I co-authored on legal issues relevant to people in the computer hardware, software, networking, and service businesses. These articles are appearing in the IEEE's computer magazine each month in 2012. This podcast is part 12 of our series. In the last podcast, we discussed recent changes to U.S. patent law resulting from the enactment of the America Invents Act. In this podcast, we will discuss some aspects of employment law that are particularly relevant to startup companies. Joining me today for this podcast is my colleague Tim Van. Tim is a partner in the Boston office of the Edwards Wellman Palmer law firm and co-chair of the firm's Labor and Employment Group. Welcome, Tim.
Thanks, Brian.
Employment law is complex, particularly in the U.S., because each state has its own regulations that not only may be different from other states' regulations, but also because there are overlapping federal regulations that must be complied with as well. Tim, how does a company that's just getting off the ground grapple with this? What are some of the first things a new company should do to avoid trouble with employment laws down the road?
Well, Brian, it's a very good question, and particularly to a startup company, it can be a little bit overwhelming. I would recommend that the first thing a startup company do is to engage employment counsel that's knowledgeable concerning the jurisdiction, the employment laws that in the jurisdiction in which that employer is located. Most seasoned employment lawyers will have a checklist or an audit of various laws that do need to be complied with. And just by way of example, some of the things that a startup company needs to be thinking about very early in the process are things like the hiring process. How are the job applications going to be handled? What's going to be on the job application? Is there anything on the particular written application that is troublesome? For example, background checks or drug testing, those kinds of issues need to be grappled with. Another issue is how the candidates are going to be interviewed and making sure that no potentially discriminatory type questions are asked as part of the interview process. Unless you've been through the interview process a number of times, there are a lot of traps for the unwary that can get an employer in trouble with the anti-discrimination laws. Another issue, of course, is characterizing the employment relationship. There are a number of startup companies that may be tempted to want to hire independent contractors initially in order to avoid paying them benefits. And very often that can be a big mistake, and it can come back to haunt the employer down the road, and there can be severe penalties attached to that. With respect to the employment relationship itself, you want to make sure that you've thought about whether you want particular employees to be subject to employment agreements, or whether you want to simply have offer letters go out, which state, among other things, that the employment relationship is at will, which simply means that either party can terminate the relationship at any time and for any reason, as long as it's not illegal. You want to think about whether you want any of your employees, particularly salespeople, to be subject to non-competition agreements, non-solicitation agreements, and non-disclosure agreements. So those are just a few of the issues that startup companies need to think about, and the sooner they think about them and engage employment counsel, the better.
It's not uncommon for new companies to have operations in multiple states or even multiple countries. For example, in their earlier stages, some companies may be virtual, with people working out of their homes and scattered across the country or across the globe. Are there employment law issues that arise with such virtual companies? For example, what jurisdictions laws apply? How is this typically handled?
Again, a very interesting question, and one that the company can control to some extent. I mentioned earlier that with respect to various employees, you may want to have offer letters or employment agreements. And in those employment agreements, it is very easy to put in a choice of law provision. Not only a choice of law provision, but also a venue provision, which provides that in the event that there's a dispute, both sides would agree that the dispute would not only be governed by the laws of a particular state, but that the lawsuit would have to be brought in a particular jurisdiction. And as long as there's some reasonable connection between the employee and the employer and the jurisdiction, that governing law provision and that venue provision should be upheld. So again, these are issues that employers, startup companies should be thinking about earlier rather than later, because oftentimes what I see, for example, in these employment agreements and non-competition agreements is complete silence on the issue of what law governs and which venue the dispute will be heard in. These are issues that are within the company's power, and if they're in the employment agreements, they're typically upheld.
Employees are pretty mobile today. It's expected that many will change jobs and move from company to further their careers. Employers obviously want to ensure that their departing employees don't take company-owned materials and information with them to new jobs at other companies. You had mentioned the non-disclosure and non-competition agreements earlier, for example. What are the typical obligations on a departing employee? That is, what would you tell an employee who came to you and said he was leaving his job for another company? What would you tell him about what he could or could not do?
The first thing I tell any departing employee is to keep his or her nose clean. Do not leave the company taking company documents or other materials with them. That's the hand in the cookie jar situation. And if a former employer decides they want to go after a departing employee for breach of a non-competition agreement, or because they've allegedly violated their non-disclosure agreement, oftentimes Exhibit A at the preliminary injunction is some forensic evidence that the employee has either downloaded sensitive information on a thumb drive or taken critical documents with him or her as they've left the company. So that would be my first piece of advice. My second piece of advice is analyze your agreements with your employer and find out what your obligations are, whether you're subject to a non-competition agreement, and if so, whether there are particular factors that may make that non-competition agreement invalid now. But again, getting outside counsel's advice on those issues is important.
And clearly that would be the employee, the departing employee, finding his or her own lawyer. He wouldn't obviously want to discuss that with the company's own lawyers prior to any departure.
Absolutely not. Good point.
One note about the so-called employee handbook. That seems to be a good place to describe employees' rights and obligations. At what point should a company prepare a handbook? What's typically included in it, and how does a company go about preparing one?
A handbook, in my view, should be prepared at the formation of the company, because a handbook, if nothing else, provides employees with a sense of what the company is all about and what's important to the company. They are not particularly difficult to prepare. We've got several forms of employee handbooks on our system that can be marked up to suit a particular employer's needs and wants. But typically the kinds of things that would be in the employee handbook would be things like issues concerning payment of wages, issues dealing with the anti-discrimination laws, and sexual harassment in the workplace, those kinds of issues, and what the company does or should do in the event that an allegation has been made concerning discrimination or sexual harassment. Thanks,
Tim, for your views on this. Employment law is complicated, and it seems like that it can change frequently at state and federal levels. It makes sense for new companies not to lose sight of this and stay in close contact with their employment lawyers to ensure compliance with the applicable laws. We hope that you found this podcast helpful in understanding this topic. Stay tuned for our next installment in Computer Magazine. Until next time, this is Brian Gaff
and Tim Van Dyke.
Feel free to contact us via email at bgaff@edwardswildman.com
or at tvandyck, that's VANDYCK, at edwardswildman.com.
Thank you.